Turning now to John O'Brien. John O'Brien is our esteemed founder, chairman of the board for the Illinois Real Estate Lawyers Association. He's got some views on where the profession is going. We like to call him the president of everything. You know, he was president of IRELA, he's president of the Illinois State Bar Association. He serves as vice president and special counsel to the CEO of Attorneys Title Guarantee Fund, Peter Birnbaum. He works with the ISBA Mutual Board of Directors. I think, are you chairman emeritus or something of that? The list of titles goes on and on. We wanted to have him give us his perspective on where things are headed.
Thank you, Ralph. Give me just a second here to get organized. And as I do, maybe just as kind of a follow-up to where the last session ended, you know, and segueing into my remarks, look at us here. We have become a thing. It's, I see, looking out in the audience, people who were present at the very first meeting back in the mid-90s sometime. I don't even know when that was. Didn't seem like there was going to be a thing then. I see people who I've not met before. I see people from all the surrounding counties. We should be proud of ourselves. We should be proud of Ralph. You know, one of the core ideas as we started this group was that when issues that affect the practice of real estate law are being discussed by realtors, lenders, regulators, we lawyers had no place at that table. Kids, we have a place at the table now. We are, all of those groups seek out Ralph. You know, he was telling about how he's been all over the state and back again. I was there with him. Not only are we there, people are falling all over themselves, state regulators and the like, thanking Ralph for showing up, thanking him and this group for our remarks and our participations in these projects. So that's a good thing. But just as I said, to segue off our last performers here, by the way, this is the comic relief, this part. You know, one thing that always concerns me, and as we discuss issues and cases and practice issues, is we have become a group that to a large part establishes the standard of care in what is the lawyer's job in the real estate field. And I'm always cautious about taking on too much. You know, as we ended with, gee, who's going to find out about that local ordinance? At least in the, you know, the context of residential real estate. Well, just speaking for myself now, I don't want that to be me, to own those kinds of issues, because we're, you know, too cramped as it is already. So I just wanted to mention that. Be careful, you know, what you take ownership of. So let's start for a minute. We're talking about the future of the legal profession. You know, as if I knew. But I will make some observations, and let's kind of start with where we've been and, you know, and where we're going. You know, the last time we have I don't know how many people are here, better part of 150, I bet. Back in the late 1990s, this group really took a big step forward when our good friends at Koenig and Stray published Closing Myth #1. Do you all remember Closing Myth #1? Closing Myth #1 said that it is a myth for sellers of real estate to think that they need to hire a lawyer to represent them in their transaction. That's just crazy talk to do that. Rather, our good friends at our captured title company, Fort Dearborn Title at that time, we will do all of that stuff for you. The only thing that you won't get, sellers, is a bill. Well, that came out, as I recall, on a Friday afternoon. We had that to lawyers all over the state, you know, by Monday morning. And these were the days, 1999, when the kid was hand faxing these things to people one at a time all over the place, because I loved that. It showed the realtor's view of our future. We are talking about the future of the profession, right? That 1999 Closing Myth #1 showed what realtors think the future of real estate lawyers is. That is to say, non-existent. And we had a meeting. Many of you were there. We had hundreds of lawyers to show up to see what we were going to do about this. We had now Justice Terry Lavin, who was then newly elected as an officer of the State Bar Association, show up and tell us that what we needed to do if this was a bet the practice issue that was confronting us, and it clearly was, and clearly remains as such, that we needed to get organized. We needed to raise some dough. We needed to hire lawyers Imagine that. Lawyers are expensive. Did you know that? It's, wow, who knew? And we took that advice, and we did something. And we wound up suing Koenig and Stray, and we wound up creaming them. They were represented by a small local law firm, Kirkland and Ellis, who ran out of the courtroom with Judge Bellick waving his finger at them, saying he never wanted to see them in his courtroom again, defending this kind of reprehensible behavior. It was a beautiful thing. But it cost us $200,000 to our lawyers, Bill and I, then at Johnson and Bell. We didn't have any money, but it was a bet the practice issue. We went around the state and raised it $50 at a time, $100 at a time, but we raised it, and we beat them, and we sent a message that we were not to be trifled with, that we think we do have a place in, in this transaction. In at least one of the booklets you got today, there's an article written by Ralph Schumann, and quoting me. I think he made this quote up because I'm not bright enough to think about this, but complaining about these practices of Koenig and Stray, and pointing out that realtors are selling, we are representing, and those verbs are different and imply different standards and caring about different things. That was true in 1999, if I ever said that, Ralph, and it's true today because we are confronting many of these same issues in this practice area. A few years later, I see Sean Bolger, and I don't want to embarrass Sean here, but everybody else does, so why not me? I'll never forget that Sean was representing some sellers in McHenry County, and in their listing agreement there was a so-called binding agreement with One World Title, which I understand still exists, and just barely, I hope. And Sean, representing her clients, had the temerity, and in this binding agreement said that the sellers agreed that One World Title would do the title work for this transaction, and since it said it was a binding agreement, it must be. So, and Sean had the temerity to say, you know what, I think it's a better idea if we use a different title company that Sean was affiliated with. Those people, as I recall, Sean, were moving to Texas, and money had to be wired that day, and Sean knew, and properly so, that she could control that process through her title company, and no idea what these other people could do. And deal closed. Sean was sued for tortious interference with a contractual relationship, namely that binding agreement. I remember this because she was served on the way to our IRELA golf outing. And do you remember this, Sean? After she went in a couple of drives, practiced her putting, she handed it to me and said, what are you going to do about this? Well, I get that a lot. And what we did about it, of course, is we stood up and said that this is a bunch of crap. We're not going to take this. We, the lawyers, control this process, not these realtors. Another couple $100,000, to get this far. These people, when they're caught in an indefensible position, what they like to do is see how much money in attorney's fees their lawyers can bill and make us spend. And as soon as we get to the courthouse steps and are actually going to have some kind of a dispositive hearing that might eventually make some law on these issues, they say, as they did in Sean's case, you know what? You're right. We were wrong. We're not going to do that anymore. We'll sign off and say we won't do this. And then, of course, a week later, there is a new variation 10 degrees over from what they were doing before, and this is their new process. And it's very, very frustrating. I had the honor, with your support, to be state bar president back in 2010, and one of the things that I was successful in doing, a couple of things, was that since we can't keep running around raising a couple $100,000 every time somebody steps on our prerogatives, I was able to convince the Supreme Court to enhance the ARDC's, I hate to say that word in public, the ARDC's authority to prosecute the unauthorized practice of law. These kinds of issues was exactly what I had in mind. I remember then Chief Justice Tom Kilbride, who was an ATG member back in another life, by the way, and understands these issues, saying to me, bumped into each other some places. Oh, by the way, we've adopted those rules you wanted. We should have done this years ago, O'Brien. I said, yeah. And it was my hope that, the ARDC, which is very happy to go bust a disbarred lawyer who's handing speeding tickets down at the Markham Courthouse or someplace, that they would take over this issue. Unfortunately, the ARDC has taken the position that anything that smacks as a turf battle, i.e. realtors and lawyers, whoa, they don't want any part of that. They say, O'Brien, here's the ball back to you again. You run with it and see if you can prosecute these cases. That a person who's very interested in this issue and is responsive to these issues was just elected Chief Justice yesterday. So I look forward to renewed discussions with Justice Carmeier about kicking the ARDC in the rear end to get more actively involved in this and other consumer-related issues, not just those disbarred lawyers that they like to chase around. Another thing I was able to do that at that time, I was at a state bar function a couple of weeks ago, actually last year already, and Tim Storm, who was the moderator of this, introduced me, and he said, because I'm falling into this again, I know, he said, there's never been a nice thing said about John O'Brien that he hasn't already said about himself. So, hurt my feelings, but was Ethics Opinion 10.02. And what Ethics Opinion 10.02 said is that a lawyer, when approached by a realty company that says, if you want referrals from this company, you may have to agree to use our title agency for the title work, that was an ethics opinion, or excuse me, an ethics violation, giving up professional judgment. You can imagine, I'm sure you've all read it, I know it's linked to here in your materials. And I was hoping, of course, that this would give a lot of cover to people who, when approached by these institutions, and God knows you all are every day, that you could say, look, this has been addressed, and I just can't do that. I get a kick out of, well, we'll get to that later. So that's kind of where we've been. Where are we now? Remember, we're talking about the future of the profession, and I'm going to talk broadly about that for just a minute. There was an ABA study, God loves the ABA, that they looked at how people do these things, I don't know, that in 2013, they did a study over mid-sized American cities, which they defined as cities of 300 to 400,000 people in population, and found that 66% of the people surveyed had a civil justice issue within the last year. That is to say, the need for a lawyer. The trouble is, of course, they didn't use a lawyer. There is a perception where we are now. You, me, we all deal with this on a daily basis from people that lawyers are icky, that they're too expensive, that there's no value added, that they can do things themselves. And in many cases, they don't even know that they have an issue. I'm not sure that that's so true in our narrow little practice area here. People know that this is at least that much, that this is a legal issue, a contract that they have entered into. And they tend to look for some other way to handle this. I found these statistics from our Supreme Court. These are 2014 statistics, the most recent ones available. This is in our little river city, our own home state, that talking about self-represented litigants. Now, I, for one, don't even know what that means or where the courthouse is, and I don't want to know. But that 88% of people who applied for an order of protection were unrepresented in 2014. 31% of litigants in the law division were unrepresented. 66% of people in general civil litigation were self-represented, pro se. Rising to 73% of litigants in small claims cases, and that in family law cases in Illinois, 49% of litigants are unrepresented. So, what does that tell you about the public's perception of all of us? They think they can do it. They think they can Google it. They think they can figure out how to do this, and it's caused a great pressure on the whole judicial system. I know, because I monkey around with the Illinois Judges Association, that the judges are confounded with how to deal with all of these pro se litigants. Do you treat them, if you're the judge, particularly in a situation with a lawyer on one side and a pro se on the other, do you look the other way on the rules for the pro se litigant? Do you, the procedural rules, rules of evidence, and all the rest of it? Or do you hold them to the same standard as, and it's just, do you give them the natural human inclination to say, you should ask the question this way? That's, how they should conduct themselves is a big issue for the judges sitting in the state. Erica, who just did that wonderful presentation, is in foreclosure court all the time. I am sure that you see this, that the vast majority of those people are unrepresented. They don't think they need a lawyer. We have, I serve Ralph Dennis Borden, who you'll hear from in a minute. We are all in the State Bar Unauthorized Practice Task Force, and we just had a discussion at our last meeting about how judges are telling pro se defense litigant or foreclosure litigants that they don't need a lawyer. Judges are telling them that. You can do this yourself. Go see the nice people out in the hall. They'll help you do nothing. This is a big problem. We hear, Phil Vacco was our Will County board member at IRELA here. We hear that this is particularly prevalent in Will County. The judges and DuPage County are telling litigants they don't need a lawyer, that the system will somehow work. Where in fact, and we hear this all the time, Judge Delort was mentioned today, spoke to us one time about his frustration that these pro se litigants think that somehow this is going to be worked out, they're going to be able to refinance, they're going to be able to do something. All they got to go is talk to those nice people out in the hallway, not realizing that whatever time limits are running are continuing to run. The fact that they're talking about doing something to reinstate their mortgage on some basis, they think that everything else has been stopped. It has not. Time limits are coming and going. They are stuck. It's a real problem. So, that's part of, what we're dealing with at the present time. We have those pesky millennials, who, God knows, think they can do everything. And just, I see Mark with his phone out. They can do it like that. He's in fact doing all his research over there right now. And they're not willing to pay for legal services as we've typically known them. They might pay for not a thorough job, but maybe enough money to do just an okay kind of job for them, whatever their legal issue might be. Technology, of course, is certainly a two-edged sword on all of these issues. The things that I'm a very old man, as you can see, probably more dead than alive. But the things that only we knew back when I was a young lawyer, or not now, why anybody can know them, that has, the time and the energy to just look them up. The secret handshake that we all learned, the first day of law school. Everybody knows that. That information is very readily available. We have new players in the legal marketplace. Am I depressing everybody? The bar opens soon, I hope. We have LegalZoom. We have Avo entering the marketplace. I mentioned the State Bar Unauthorized Practice Task Force. We were, back years ago, we were mad at LegalZoom. We thought this is a bunch of crap, some online service selling forms to, the citizens of Illinois, that is to say, our clients, on how to more in a transactional basis, let's call it, the wills, the trusts, the taxes, the incorporations, the partnerships, those kinds of things that you hear advertised every 5 minutes on every channel now, right? And we thought that there must be some way to prohibit this. This stinks. This is, certainly can't be allowable. We always thought naively that, where this always fell down is they said, all we're doing is selling forms, they would say, but the question always is, which form do I need? And as soon as somebody answers that question, that's the practice of law. And we thought that's how we would have them. Well, kids, that ship has sailed. There is LegalZoom. It's not going away. They've tweaked their, the way they do things. You hear these ads, that there are lawyers on call, that, it's not, the part-time student summer job, answering the form and saying which form, you're now directed to a lawyer in your community. They're much more sophisticated. They're here to stay. That slice of our traditional practice and business and revenues, it's just gone. It just is. Recently in North Carolina, I've spoken about this before, but I might as well mention it again. North Carolina was really mad at LegalZoom for all varieties of mopetry that they had perpetrated over the years in North Carolina. And when LegalZoom decided that they wanted to establish a legal services program in North Carolina, one of these programs where you can pay a premium, let's call it, you can get a lawyer for a traffic ticket and a will and those kinds of prepaid legal services programs. The state bar, it's a unified bar in North Carolina, so that's the state bar does those functions that the ARDC might do in Illinois and others. They gave them a hard time. The Federal Trade Commission, we're from the government, we're here to help, heard about this, and they had been involved with the dentists in North Carolina. And in the dentist case, there was a board, and we have a million of these in Illinois, composed of, I think it was 7 dentists, a dental hygienist, and a layperson, and they licensed the practice of dentistry in Illinois. We have a million of those things for, here in Illinois. And people who do the teeth whitening came into North Carolina and set up booths, literally booths in shopping centers and the like, say we will do teeth whitening. And this board, consisting of practicing dentists, said that's the practice of dentistry, you can't do that, and effectively ran the teeth whiteners out of North Carolina. The Federal Trade Commission heard about this, sued the Board of Dentistry in North Carolina, saying that you can't have a situation where you have interested parties, marketplace players, i.e. the 7 dentists on this commission, deciding on their own what is and isn't the practice of dentistry. And you have no mandate from the legislature. Nobody's spoken about this. Nobody empowered you to do this. You can't do it. And so the teeth whiteners are back. The lawyers, 6 months later, less than 6 months later, did the same thing to LegalZoom, decided, no, you can't come in with this program to North Carolina. LegalZoom sued all of the active members of that committee of the State Bar of North Carolina and basically said, didn't you read this opinion? And this, by the way, the dental whiteners was a U.S. Supreme Court, went to the U.S. Supreme Court, Justice Scalia, and the lawyers caved in North Carolina, maybe the last fight. So LegalZoom is here. AVO, they were just sued in federal court here in Illinois. Maura Bernstein, who's actually a member of this organization, kind of a convoluted theory she had, but her case was just dismissed against AVO just within the last couple of days. I think it's even in some of the materials here. So these places are here. They're not going away. They are your competition. They're our competition. And that's just seems to be the way people want their legal services delivered to them, unless they're a great, huge corporation. So we have all these new actors in the marketplace. What has that done to practitioners? There is a statistic that the State Bar compiled. Again, this is a 2014 statistic, that the average income of sole practitioners in Illinois is $70,000, $70,000. Now, given the debt load that young lawyers have, from their law school experience, you all are familiar with this. That's not enough money to open your office doors, if you even have an office anymore. It's just to service that debt load, to pay your mortgage and all the rest of it. But that's the reality, that consumers of legal services have spoken on these issues, and they're not real interested in us. If the numbers don't lie. So what do we do about it? Before I get to that question, there are alternative business structures that are getting a lot of press, specifically the triple LTs from the state of Washington. This has been everywhere, licensing non-lawyers who have taken, frankly, a lot of classwork, a lot of hours, but they are licensed to do certain things, and in Washington, including conduct real estate closings. not non-lawyers. Now, there is some evidence that that's partially, at least in Washington, a response to a crazy state in the woods with Sasquatches running around and, in vast areas of the state where there are no lawyers, and there was a need, maybe a different need than we have here in Illinois. I can tell you that I've spoken with the current Chief Justice, Justice Garman, about this issue, and she has no interest at this in Illinois. And I'm sure new Chief Justice Carmeier doesn't either. So these are all threats to us. What do we do? Well, I think one of the things that we do is this: that we stand together as we have in the past, that we continue to do a good job to impress the citizenry of Illinois with the value that we add to their experience. And you all know in your heart of hearts that you really, really do, for that $400 or $500 or $600 that you're making from these closings, you are making a difference for your clients. You are, in fact, representing them. You do this on a daily basis. It's all anecdotal, but you do. Each and every one of you could tell a story about how you saved some poor mope client of yours from stepping in the poop that they didn't even know was there. And, and that's what we lawyers do and have always done. Another thing we do is we don't allow people to tell us what is the practice of law and what isn't. We remain steadfast, I think, when people with yellow and black signs say, if you want referrals from us, you must use our title company. So, Randy, who do you want to be? Do you want to be the lady that gets Baird & Warner referrals, or do you want to be the lady who doesn't get Baird & Warner referrals? Well, thank you. I know you don't need them. You're independently wealthy, but many in this room do. And that's not, I can stand up here and tell about Ethics Opinion 10.02 and how you can wave that in their face, but that is a hard question to answer if you have a big mortgage and 3 little kids and don't know how you're going to put them through college. It's a very hard question to answer, but I think we do have to answer it. I do think we have to stand together and let them know, as this group always has, that we are here, we do bring value, we do represent, we do different things, we're just fine, and we don't have to buckle to this pressure. But again, remember, this title insurance business, as we again concluded the Chilton case, that the Supreme Court has this case now. We won, at least I think we the lawyers who are, engaged in title insurance as part of our practice, we won this case. Remember, the class action lawyers were asking that all those lawyers at Ticor and Fidelity during that or at Chicago Title during that time period disgorge the money that they made from those. Dennis, you want to disgorge all the money you made in? That's a very scary comment. The Supreme Court now has this case. Why did they take it? If one might wake up at night and worry about this, as I do. Maybe they took it because they don't think that lawyers are entitled to that compensation, that they think Justice Paczynski, who used to be an ATG agent also, and said, in her opinion, if you read it, this is bullshit. People are walking out with checks for $2,000 and they spent 10 minutes maybe, on this. I know how this works. This is clearly pay to play. This is clearly kickbacks. We'll give you a referral. Use your title company. We'll pay you a bunch of money, and everybody will be happy. Maybe that's what they want to look at. Joe mentioned how he was able to convince the court that we lawyers work like dogs do, all of this title work. But there are, citywide title, not to pick on them, but what the hell, let's pick on them. They say we work like dogs and therefore we're entitled to be compensated. And Citywide says, place your order with us, we'll do all your Schedule A clearance work for you. You don't have to do a thing, counsel. We'll order your payoff letter. We'll get your condo stuff. We'll do everything. All of those things that the expert witnesses in Chilton said, that they do, and that's why they're entitled to make money for, in addition to doing the title examination. We'll do that for free. We have another title company in the western suburbs that says, place your title order with us. Not only will we give you the highest split around, but we'll give you on each file an extra $300 bonus just because. How can that not be a RESPA violation to say we will give you $300, not for doing anything, but just for placing the order? Isn't that a thing of value? That's what's going on in the marketplace. We need to control this. We need to not give in to these things, in my opinion. We need to do what we've always done, to represent our clients. Ralph, how am I doing in time? I got to be just about done. Okay, 2 or 3. So what's the future of the profession in Illinois? So it's up to us to make it. I don't know what it is. It's different, that's for sure. It's not. I was part of my gig at Attorney's Title. I do called member visits. Go out and see some of I see Ray Carlson. I've been in his office. He still has refused to buy me lunch, even though I go out there every year. Broadly hint how hungry my stomach. And I'm like, no, not him. I was in some members' offices the other day, and it was a big day for them because they had just received the pocket parts for their Smith Heards. Younger lawyers don't even know what I'm talking about, and they were gleefully putting the new pocket parts in all of their law books. And I don't know what the future is, but I know what it ain't, and it's not that. They just were so happy they couldn't. Banner day at the old law firm. The new pocket parts are here. So embrace the future. Don't deny it. There is LegalZoom. There is technology. There are competitors in this marketplace. Know that you have a friend. There he is. It's Ralph. Call him. Or call me. I'm always around. Call me. Better call me. Come to think of it, so. Thank you for this opportunity. Again, I'm proud of all of you. Again, we have become a thing. IRELA has, and here it is. Thank you all.